same treatment that male service members would obtain. Okay, now the complicated part of Frontiero is that there was not a single majority opinion. Right? On the Supreme Court, to have a majority opinion, you need 5. Right? 5 votes will let you do anything you want. Indeed, Justice Brennan would often tell his law clerks, what's the most important? This story might not actually be true, but it's told enough that I'm comfortable saying it. But the story goes that Brennan would often tell his law clerks, what's the most important number at the Supreme Court? 5, because with 5 you can do whatever you want. Even if it's not true, it's true. Brennan could not get a majority opinion. There's only what's called a plurality, right? What's a plurality? Think of Bakke, right? You have an opinion with 4 justices, and because there's no majority, that opinion controls. But it doesn't set a precedent, right? So the Brennan opinion in Frontiero does not set a binding precedent. It resolves the case here, right? In this case, Sharon won. Frontiero won the case. But the reasoning in Justice Brennan's majority opinion did not control. Why? All the justices agree that this policy was irrational, right? All 9 of them agree that this would flunk rational basis, right? That denying the benefits to the husband when you give it to the wife makes no sense, right? But they couldn't agree on a rationale. So let's start a little bit backwards, right? Chelsea, why would this policy flunk even like a rational basis review, which is what the concurring opinions get at?
Because it's directly, I don't want to say discriminating, but regardless of the reasoning that the government needed to fit
Yeah.
any type of.
Well, what's the objective that this sort of policy is pursuing? Why does the government have this policy in place?
Is that, isn't it fraud or?
How does this policy prevent fraud?
Because, like you said previously, the husbands, they assume are double dipping, and so.
Oh, they're afraid of double dipping. Very good. Thank you, Chelsea. So the presumption here is they want to reduce fraud because if you're a husband, you're probably working somewhere else, and they have to make you go through perhaps income verification to show in fact you do depend on your wife. Is that not a legitimate interest for reducing fraud?
Yeah.
And is it not a reasonable way of reducing fraud to go after the people most likely to be committing fraud? Is this like irrational?
No.
Fletcher, you're shaking your head, yes.
Oh, I meant like, no, it's not.
Hold on. It's not irrational. So you think this is a rational policy?
Yeah, it meets the rational basis.
It probably does. Yeah. Right. If we take Lee Optical to be the prevailing standard, right? Does it make sense to have eye doctors give out lenses instead of the opticians? Sure. Right. Maybe they'll find an eye disease. Maybe they won't. Right. If we find that women are more likely husbands are more likely to commit fraud, is it rational to let the government have this policy that they just scrutinize some claims, not others? Look, the government can, of course, Audrey, let me ask you this question. What could the government do if they worry about fraud instead of having this policy? What might an alternate be? They're worried about applicants committing fraud. What else might they do short of having this gender differential?
I mean, I guess just, I'm not good at these policy questions.
No,
I guess,
it's easy.
I mean, just create some type of law to I have no idea.
Look, if they find that they're going to need to put more resources to scrutinize the applications, what might the state do to avoid this sort of problem?
I don't know why my brain's not working.
I'll come back to you. Tyler, what could the state do as an alternate?
Just review them all.
Review them all.
Oh, both.
Review men and women alike. Does that have any constitutional problems?
That's easy. I should have known.
No, right? They could simply review all the applications for fraud. But wait a minute. I'll come back to you, Audrey, right? That's expensive. right? At this time, if I had to guess, and Tyler, you can correct me, but I'm guessing 90-something% of the officers were men. Is that a good guess?
It's fair. Yes, sir.
Probably high 90s. So we're talking a very small number of husbands here, right? Why should the government have to scrutinize, let's say, thousands of female applicants when there are only maybe a handful that are suspect of fraud? Why can't the government just choose to focus on the areas with the most likelihood of fraud? Is that not a rational way of going forward?
They said that no, it wasn't. 'Cause
Right? I said, is it a rational way of going forward?
oh, I guess.
Yeah. So I think what you're seeing here is the court, all 9 justices agreeing that this is not rational. But under the sort of Lee-optical rational basis test, it certainly is. Right? You're targeting your efforts on the area of the highest incidence of fraud. For sure, in the next case, right? If you find that men are more likely to get into DUIs, why wouldn't you target them for higher drinking age? But this law reflects, I think, how Ginsburg argued the case. It's based on a stereotype. It's based on a stereotype that women belong in their home, and their natural roles, they have a homemaker. Think of Mueller with the blood in the water. Right? Think of the Bradwell case with the women attorney. That's their role. That's what nature says. And it's not rational to base a policy solely on that ground. Now, we don't even know if this fraud example is real, right? The court kind of hints at this, but it might not even be a real thing. It might be fake, right? There might not be any evidence of fraud. But under rational basis, you need evidence of fraud. Maybe they're trying to stop a problem that doesn't exist yet. Maybe they're worried that fraud might occur in the future. Generally, that'd be enough for rational basis, but not here. Right? So, okay, Audrey, please.
I have a question on today for insurance reasons.
Yeah, someone always asks this question.
Oh, okay. 'Cause
You can ask, go ahead.
I'm confused on-
How come girls have lower premiums than guys?
Yeah. 'Cause it's
The short answer is it's not a government classification. Insurance is offered by private parties.
oh,
But the related question is, could an insurer charge a woman more for health insurance
Yes.
than for men? And the answer is basically no, because of the Affordable Care Act, right? There's often long deemed as saying there's a penalty for being a woman with insurance. That being a woman was a pre-existing condition was a line. The reason why is women get pregnant and men don't, as a general, I suppose. And pregnancy is a very expensive. I have a 6-month-old. I just went through this. It's very expensive. It's a very expensive process from start to. Thank God everything was healthy, but it's still very expensive. If you look at the hospital bill for a delivery, a healthy delivery, natural, not cesarean, a healthy natural delivery, it's insane the amount of money spent in 2 days. But under current law, women, they can't be charged more, but a lot of the things that make health insurance for women more expensive now have to be covered automatically, which basically raises everyone else's costs. That's how Obamacare works. You make one part cheaper, and then you have to raise other parts. That's everything goes out.
It's not pre-existing conditions. What are they called? The non-negotiable things that are in
Essential benefits, minimum essential coverage.
Okay.
Yeah, there's certain things that everyone has to pay for, whether you want them or not.
Is it because of the reasoning, like, or just because, well, the reasoning's not binding, but never mind. But I guess they talk about, like, the history of women's
Yeah.
rights.
Yeah. We'll get to the the Brennan opinion in a minute. But as a general matter, all 9 justices agree that you need to have something more than a rational basis. Right? The question is, what does that then look like? Justice Brennan, who wrote the plurality, argues that strict scrutiny is appropriate, that classifications on the basis of sex, that's actually the name of that new Ginsburg movie, right, On the Basis of Sex? I didn't see it. I saw the documentary, but I didn't want to see the movie. I think I was disappointed by the movie. But classifications on the basis of sex are inherently suspect, right? Brennan explains that these are classifications based on immutable characteristics. What does immutable mean, Lindsay? What's immutable?
They're inherent.
You can't change it, which again is not a judge in the Fifth Circuit recently had a case involving transgender rights, and he basically cited Justice Brennan for the proposition that your sex can't be changed, it's immutable. And he pissed people off with that one. But at least at this time, sex was considered immutable. So Lindsay, why is it important that sex is immutable? Why should that factor into the question of whether it's a suspect or quasi-suspect class?
Because the other suspect classes are also immutable.
Bingo. Race. You can't change your race. You can't change your nationality. Brennan says you can't change your sex. And because you can't change it and you're stuck with it, these sorts of classifications are especially troubling because they're going to be based on something that's not your choice, right? By the accident of your birth, you're a man or a woman, you're white or you're black, and the government's classifying you based on something beyond your control, right? It's not like they're classifying an ophthalmologist different from an optician, right? Or they're classifying a 16-year-old different than an 18-year-old. They're classifying you based on your sex. So Brennan gets four. No, he gets four. He gets 4 votes for the proposition that classifications on the basis of sex are suspect, and laws that violate those, or laws that classify people on that basis should be reviewed with strict scrutiny. Yeah, Audrey.
So if sex ends up becoming a choice, would courts now use rational basis for sex and not strict?
Well, Frontiero was not a majority opinion. Craig v. Boren actually held that sex was intermediate, a quasi-suspect classification.
So it would be.
Well, let me put it this way. In modern day arguments about LGBT rights, the word immutable has faded, right? That's not that doesn't come up as much as it used to, because the modern position is that gender can be fluid and is not fixed. It's not immutable. Indeed, sexuality can be fluid. It's not fixed. So that's why when that judge in Fifth Circuit used Brennan to talk about sex being fixed, he pissed people off, because that's not how these arguments are framed today. Indeed, there's a huge debate about whether, we'll just take gay rights, for example. If the state bans sodomy, is that a prohibition on conduct, that is sex, or is it a prohibition on status, that is the fact that a person's gay? And the movement has been, at least on the liberal wing of the court, towards status-based rather than any sort of specific conduct-based. But these are issues that I think are in flux post-Kennedy, and I don't know how the court will resolve it. Kennedy never really cared for a tier of scrutiny. He didn't really care about it. And so his failure to garner 5 votes for that position now make it much simpler for 5 justices to go a different direction, I think. That makes sense? All right, so the holding then in Frontiero is that there wasn't a holding. All 9 justices agreed that Frontiero should win, but they couldn't agree why. So you don't have an actual precedent being set. You would get that precedent in the next case, Craig v. Boren, 1976. All right, any other questions on Frontiero? If you didn't watch the video, I'll just play it now. I sent this to Reporter earlier, so I have it queued up. Just so you can watch the Ginsburg bit for a bit if you didn't hear it. Yeah. Did I play this all last time or no?
His wife. However, Sharon Frontiero's request was, quote, denied because she failed to demonstrate that her husband was dependent on her for more than 1/2 of his support. Ruth Bader Ginsburg argued Frontiero on behalf of the American Civil Liberties Union. She contended that the law was premised on a stereotype, which
assumes that all women are preoccupied with home and children.
Such stereotypes
Help keep woman in her place place inferior to that occupied by men in our society.
Therefore, Ginsburg urged
The court to declare sex a suspect criterion.
Ginsburg secured 4 votes for her position.
Anyway, so that's how Ginsburg
Justices
sounds.
Brennan-
She sounds quite different today. But I guess when you're 86 or 87, you get a little bit of slack. Remarkably, she had cancer. I mean, she had surgery this year, and she was still the first one back in court. She had the first opinion after the term. So it's still a pretty remarkable term for her. All right. Any other questions on Craig? I'm sorry, on Frontiero? No? Okay. The second, excuse me. The second case is from 1976, so 3 years later. Craig versus Boren. Who's next? Chelsea, I think you're next. Can you give me the facts, please, in Craig v. Boren?
So Oklahoma passed a statute that prohibited the sale of non-intoxicating 3.2% beer to males under the age of 21 and to females under the age of 18.
Mm-hmm.
An action was brought in the district court for the Western District of Oklahoma by Craig, who was a male between the ages of 18 to 21 and a licensed vendor of 3.2% beer.
Okay, very good. Thank you. By the way, has anyone ever had 3.2% beer? I occasionally have students from Oklahoma who actually know what this stuff is.
Like, yeah, I went to OU.
Is it like just doesn't get you drunk?
It's just a little under Texas, so I didn't really notice the difference.
Okay. All right.
But yeah, I guess.
Oklahoma here had a law that treated men worse. And indeed, the lawsuit was brought in part by a store owner. It was called the Honk and Holler grocery store. And I finally figured out about a year ago why it's called the Honk and Holler. It was a drive-through where you would honk your horn, shout what you need, and they bring your goods in a paper bag. It's called the Honk and Holler. What a wonderful name, grocery store. Like a little convenience store. So let's start at the basic level, right? Audrey, how did Oklahoma defend this law, right? What was her defense
They had
of this age differential?
They had statistics that showed that men, overall, they showed that men were more likely to get in a driving accident under the influence than women.
Okay, very good. Generally, Audrey, if the government comes forward with evidence to demonstrate that they need a policy because it promotes health and safety, is that enough?
Generally,
Yeah.
it is, 'cause they have
Yeah. Right. This is not like Lee Optical where they said, well, maybe it will be good for eyes, maybe it won't, right? This is not like Craig Frontier where they said, maybe there's fraud, maybe there's not. Here, they actually have statistics showing that women get into accidents at a lower rate. And indeed, your comment about the car insurance probably reflects that fact, I think, as a general matter. An 18-year-old woman is probably more mature than a 21-year-old guy. I might get in trouble for saying that, but I think it's generally true. I sure as hell was not very mature at 18. But they actually had numbers here. Tyler, were those numbers enough for the court?
No.
No, why not?
At the end of the day, it wasn't about the consumption. If they were wanting to legitimately address or accomplish their end, their interest, they would have barred consumption. Their data wasn't convincing in that it was a legitimate means, to their public safety argument.
So in other words, what law would the state have had to adopt to pass scrutiny here? What law could they have adopted?
So I don't know. I'm curious. There wasn't like a
Would
constitutional 21.
anything work?
They said that they couldn't consume it.
Ah, okay, that's what I'm looking for, right? What if the state said it's a crime for women at 18 could drink it, and then men at 21 could drink it? Would that be okay? Do you think Brennan would think that works? that would have a tighter fit, right? Because they're actually going after the problem, which is consumption, not necessarily drunk driving.
Is it still discriminatory? I think so.
So you think, would that pass scrutiny?
Wait, I thought the end was traffic safety.
Yes, right. So how is banning the sale connected to drunk driving? Right? Banning the sale isn't closely enough related to whether you actually drive drunk. This merely bans the sale. Tyler proposes a different law that actually bans you from consuming it. Or I'll go on more, make it different penalties, right? That if you're a woman, you're pulled over, you get one penalty for DUI. And if you're a man, you get pulled over, a different penalty for DUI. That's another possibility. But I think this is all academic. I don't think the court would uphold any of these statutes, because they're all based on a stereotype, which might be true, might not be, that women are more mature and can handle their liquor at the age of 18. Justice Brennan explains in his opinion that we have this romanticized image of girls, who the cops won't arrest, and they'll give a ride home to their father instead of throwing them up in the locker. So even the statistics are wrong, right? That so long as you have these stereotype-based generalizations, you're not going to survive constitutional scrutiny. The upshot of this is it becomes very hard to ever treat men and women differently in light of government policies. So we can get the general gist of Brennan. Justice Rehnquist in dissent is very upset, and he says, government officials should not need like a PhD in statistics, right, to prove to the satisfaction of the court that their policy is narrowly tailored enough. I think Brennan would respond, it doesn't matter if you have a PhD in statistics, we're not going to let you generalize. So even though the court adopts intermediate scrutiny, it looks a heck of a lot like the standard for race. It looks an awful lot like the standard for strict scrutiny, right? The difference between strict scrutiny and intermediate scrutiny is very thin. And that difference is eroded even more after the Virginia case, such that the two are very similar, right? I think it's very tough to think of a policy today that would survive intermediate scrutiny but not strict scrutiny. I think they're very close together. All right, everyone with me so far? Here the court adopts what's basically called intermediate scrutiny. They don't call it that here, but that's what it came to be called. And at the very end, Brennan gives the test, right? He says, the relationship between gender and traffic safety becomes far too tenuous to satisfy the requirement that the gender-based differences be substantially related to the achievement of the statutory objective. He didn't get that, that's fine. Brennan would always do this where he had to vary in the opinion, he would bury language that comes to be very important. But he was able to get 5 votes for the position that you need not just a rational relationship, but a substantial relationship, right? Even if having those statistics would get you to rational basis review, right? That it makes sense to restrict alcohol to reduce drunk driving. That might be a rational relationship, but it's not substantially related, right? Highway safety for sure is important. So what's important here is the fit, right? This case turns on the fit. How closely related is banning the sale of alcohol to keeping highways safe? Brennan says not close enough. Ban consumption, ban drinking while driving, but don't ban the mere sale, because that is too much based on gender-based stereotypes, which are impermissible. Questions on Craig v. Boren? questions on Craig? After Craig, it became an open question of what actually is the difference between strict and intermediate, right? Is there anything that passes one but not the other? I think the next case, Virginia, is a good illustration, right? Here, the state wasn't enacting some sort of law that gave women a benefit, like in Craig. Here, the state was enacting a policy that gave a detriment, a harm, to women because of their sex. Okay. Who's next? I think, yeah, thank you, Lindsay. Lindsay, you want to do the facts, please, in U.S. v. Virginia, 1996?
VMI was an all-male military academy in Virginia, and the United States brought suit against Virginia, saying that the male-only admissions policy was unconstitutional because it violated the Equal Protection Clause.
Okay, very good. VMI is an old college. It's been around since, I think, before the Civil War. And its mission was to train citizen soldiers. You're rolling your eyes there, Tyler. Just tell us what you really think, 'cause I know you have an opinion here.
I liked schooling it, so it just was pretty dicey.
Oh, it was dicey. So why are you rolling your eyes, my friend? What's going on?
It's within, within this.
Okay, he's a Marine, so just lay it on us.
On the tiers of what we call air quotes service academy.
What is that? Air quotes?
Service academies.
Yeah, scare quotes, yeah.
A&M, the Army's Naval Academy, West Point, all of those different things. That's the DMI is. It's kind of like the junior college and service academy.
Whoa, the JUCO.
Sir, it's like so A&M. The ring is kind of our thing. DMI designed theirs specifically to be 1.5 the size of ours, so they're huge and obnoxious, and it's an entirely
spoken like a true Aggie.
Yeah, level, but it's the adversative thing that he mentions. I understand it in mentality, and within, like I said, the service ranks, VMI is not there. It's more like a quasi-military training center.
Okay, so when you went through boot camp, was it sex segregated?
We were, as a company, integrated, but we had different platoons, 6 platoons of just males and 1 exclusively female.
Did you have like interaction with the female cadets?
Yes, we would go through like lecture classes, and we would work out with them all.
Did you find the integration sex have any impact on your training?
No.
Okay. So was this just bullshit, right, from VMI?
So approximately 10% of our day was spent integrated. The other 90%, it was all same-sex segregated, and it was very, what I would assume to be a different culture. It was when we would train with the females, there would be a lot more PC tone and some of the things that.
Is that among the students or the instructors?
The instructors, right. And so the way that it was orchestrated was a little bit different, but most of the training occurred in that other 90%. So based on tradition, you could say that, there was a time where the Army, Navy, Marine Corps wasn't integrated. However, we still accomplish our objectives of being a premier fighting force. So they wanted to, based on the traditional aspect, but at the end of the day, that should not preclude them from still being able to deliver the same standards.
So, and be candid as much as you want, or if you don't want to say, don't say, but do you think there was any diminution or diminishment in the training because of the integration, in your experience?
No, absolutely not. No. If you want to make it work, and the government had to make it work, we'll find a way to make it work. And BMI was hesitant, but the other service academies by this point had already gone through integration.
So what about the Citadel? Has the Citadel been integrated at this point? 96.
96? I think so.
Because the other service academies were all public, right? Citadel is private, I think, right?
Maybe.
I think Citadel is private. I'm not
I
sure.
don't know.
I'm not sure. It's not unimportant. I think it's the other big one. Citadel, I think South Carolina, right?
Right.
I appreciate that perspective. Every year I have a couple of service members who give their insights from boot camp. Right, I would flunk out boot camp at 5 seconds. I wouldn't even make it off the bus. I'd be crying, calling my mom within just like 2 minutes, forget it. So I can't even imagine sort of mental rigor. But in your mind, the sort of, I don't know the word, the adversative, I don't know the synonym for it, but just sort of the mental preparation, that can be done even with integrated cadets?
Absolutely. I mean, it would have been different if we were cohabitating. If the 6 hours a night that we were sleeping, we had been sleeping
The same
together
bunks.
and showering
You think
together,
that'd be a problem?
that'd be a whole different level, but that's not how it was.
Okay, so actually Ginsburg, I think there's a footnote in her opinion somewhere where she says, certain types of sex segregation can be permitted for modesty, right? Well, I think she's again bathrooms, right, showers, and the dorming facilities, right? So I think even Ginsburg would agree that you can separate people into different bathrooms, changing facilities, dormitories, based on sex, but the educational components, the training, the PT, that can be done all integrated? Okay.
Yeah, I will tell you that, from my perspective, females had it considerably more difficult because they knew upon arrival that their standard of performance was going to be more strictly scrutinized by the instructors who were males, etc. And even the instructors who were females were harder on the women to meet the standard and then exceed it and not receive any special consideration. I would never, just hearing some of the things that the female drill instructors would say to the other females were considerably more demeaning and colorful than the males. Absolutely.
What's the washout rate? I don't mean to put you on the spot, but your knowledge may force you here. What's the washout rate at boot camp for Marine Corps?
The attrition, so within OCS, I mean, it's their objective is they don't want to graduate any more than 70% of those that enter.
70, okay, so,
and that's looking at things such as academic performance, physical performance, cultural fit, Marine Corps knowledge, overall ability to understand fundamentals of leadership and recitation, upon them. Those things aren't different, in terms of male versus female. The only difference is if you were to look at them side by side and what's required is, okay, so for a 3-mile run, men get 18 minutes, females 21. That's it. And you can look at, they're all backed up with biological studies that says only this percentage of the population in the United States who is female can perform to these standards. The likelihood of all of them wanting to be in the Marine Corps is, extremely, extremely low. Therefore, we'll focus on what the majority of this population can do, and we'll take the top 1.5% of them. Do
they have different duties once enlisted because of their lower physical standards, or some things that different heavier packs? I don't know what an example.
No, all that was the same. So 120 pounds. I mean, it doesn't matter if you're Audrey size or your size. It's the same pack.
Hey.
List. I mean, it's the same. It's the same list. There's no standards, and until recently, the only difference is you wouldn't see females in combat arms.
That's changed.
So I mean, now they go through IOC. They go
IOC?
Through, infantry officers course.
Thank you.
Ranger, the training, and they perform the same thing. So that's now there's not, hardly any differences other than those minimum physical qualifications.
Yeah, this comes up also with firefighter exams. You hear this a lot, where the part of the firefighter exams, you basically put like this heavy thing on your back and climb like X flights of steps, and then at least in New York City where I'm from, there was a very high failure rate for women on the test, and they were given basically court orders to let women take the test over and over again to pass. This came up quite a bit. I don't have any strong. I'd fail in 5 seconds. You don't want me in a building. I'm in trouble. I have a ladder in my thing I can put out the window.
They just raised how many times they could take the test, but they didn't raise like how much.
Is that in Houston?
No, I'm asking.
There was a court order basically mandating the New York Fire Department to give women more chances to take the test. I don't think it was lowering the standard. I think the way it worked was if you failed it X times, you couldn't take it again for some time, and they were required to give another shot at taking the test to pass.
One thing that was interesting, because I was in legal for a little while before logistics, is when we were, within the coalition, and it was us and British Royal Marines and some UK forces in Iraq, is they're fully integrated. There's no the European forces. There's no separation of showers, restrooms.
Really?
Fully 100%.
They shower together. They sleep together.
It's all the same facilities, right?
Wow.
So here's something that's interesting: is the number of sexual assaults in this group
Lower.
is significantly lower than where we're not yet fully integrated, and that's in both male, female, and
Really?
other classifications as well. So there's some merits, that have been statistically proven, and I bet VMI probably saw some of the same things afterwards. I bet if you were to ask them, there's not been a significant decline in their rigor. The female probably had not much. If they wanted it to voluntarily enter that institution, they knew what they were walking into and were able to perform without this big perceived backward step.
Fascinating. Anyone else want to ask me? I don't want to put him on the spot, but it's just, I love learning from students. My God, I would have flunked out in 5 seconds.
Yeah, you'll know somebody. Have you ever met somebody from VMI?
He was kind of a jerk.
He probably looked like he won the Super Bowl with the ring on. Yeah.
Do you not wearing an Aggie ring?
I don't know.
You're the only one?
I just
I've never seen one. They're very proud of them.
no, I got my diploma on my wall. I'm good.
Okay. I knew a guy from VMI years ago who was kind of a jerk, but I don't remember what his ring was like. I worked at the DoD civilian side, not military side, so I know a lot of these guys from Virginia. Okay. By the way, this is Miranda. I don't want to detain her. She was in my class last year, right, for property?
Both, yeah.
Yeah, but both,
1 and 2.
property 1 and 2, and she's also was my research assistant, and she's on Law Review, and she has a brief announcement. And I don't want to detain you forever, so you can come on up and make your announcement.
We're having a second write-on competition with Currents. So the packet's going to be sent out on the 26th, and we're doing something different, and we're going to have an info session, Q&A, probably on the 27th to help you guys work through the packet and teach you all the basics of academic writing. Just letting you notice it's because people wrote briefs, and that's not what we're looking for. We want academic writing. I also need to mention that you need at least 4 remaining semesters. That includes summers to write on, and you need a GPA of 3.25. But there's going to be an email with all the dates and times, and another info session will be, a general info session will be scheduled.
You said at least 4 semesters or no more than 4 semesters?
Well, you need to have 4 remaining semesters, including summer semesters. So if you were a spring start, you can have summers included in your to count. So you just would register for Law Review in the summer, and that would be your semester. So you could do fall, spring, summer, fall, and then spring. You just need, because I'm gonna be my 4th semester. My last semester at school, I'm gonna be off Law Review because that's already done my 4th.
So if we're spring starts, we can do this next round?
As long as you have, including summer semesters, 4 remaining semesters before you graduate.
4 remaining.
So you can, I would highly recommend if you're a spring start to do it now rather than wait until winter, because there's going to be a winter write-on as well. There's usually a summer and a winter, but we're doing a second summer write-on, and it's going to be just a note. There's not going to be any editing exercises, just a note. As far as what I'd like to be agreed upon in the meeting. That may be subject to change, don't quote me, it's going to be an email, there will be an info section in that email. And also, if y'all want, I can give you my email, so if you have questions.
Yeah, if you want to write this, there's a marker.
Just
Here.
my name.
There's a marker right. Oh, there it is on that side.
Do we have to have a certain amount of hours already?
No. You just need the 4 semester remaining requirement. So I'll just write my name, and that's going to be my STCL email. And if you have any questions come up, you can just email me, and if I don't know the answer, I will direct you to the person who does. but I highly, highly recommend y'all write on, try out, and it's really, I'm excited.
It's a very worthwhile experience. I was on law review.
Yes.
It's a lot of work. I don't want to trivialize it.
No.
It's a lot of work, but it's also very rewarding. You will hone your writing skills in a way you will not do in legal writing. You will also hone your researching and blue book skills in a way that you will not do in legal writing. You take it to the next level. The entire thrust of law review, and the other journals are similar in that regard, is you have to pick either a case to write about or a topic of law, and you develop basically an article from scratch. And you're coming up with some novel thought, something that people haven't written about before. And that's a very difficult concept. As you sit here in this class and others, and you think of, wow, that's a good thing, I don't know about this, and that doesn't make sense, well, that's the sort of thing you want to write about. And there are a nearly infinite number of topics that you can consider diving into. The write-on is painful. I don't want to minimize it. It was over a week. How many days there, Miranda?
We try to give them at least 2 weeks, but
Oh, 2 weeks. That's
between
nice.
10 days.
I think
and
I had
8 weeks.
10 days.
It might be 10 days, but it's just going to be a case note, so you're not going to worry about any.
Is there blue booking exercise as part of that?
I don't know. We're going to do it for just this write-on because you have to do. But we're increasing the footnote requirement, so you're going to have to do probably 60 footnotes from scratch. So that's kind of, if you can't do those footnotes, you're not really.
Can't hang.
Yeah.
And is there a grade requirement or no?
3.25 GPA.
Okay. Yeah, I remember the write-on. I think I had a week. I don't think I had 10 days, and it was painful. You basically have to just get a packet of material, and you have to review it. It's a lot of work.
So yeah, we're just going to give you, I think it's just one case, and you're going to write a case note on that. But we are going to be having that info session to explain how to write a case note. If you have any questions and you get the packet, I would highly suggest coming to that because we've never done that before. So it's going to be a new thing, and we hope it works. Yeah, and I am the senior note and comment editor, so.
Oh yeah, you'll probably work with Miranda.
I hope to see some of y'all in my groups next year. That's my email. If you have any questions at all, please email me.
All right, thank you so much, Miranda. Oh, I encourage you to apply when you can. Okay, I didn't want her to sing it for the next hour. We got still a class to go. I actually feel bad. She came by at the end of class yesterday, and we'd finished early, and I completely forgot. So she came. There was no one here. I feel terrible, so I don't want to detain her further. All right, but Tyler, thank you for that.
Sorry. It looks Citadel integrated in 95.
Oh.
95.
So right around the same time, this case came up. So this was the last one, I guess. Because I think the service academies, West Point, Air Force, Naval, I think the academy some years earlier. In the 80s or the 70s?
Right, A&M was around the same time with their Corps cadets.
All right, well, let's walk through the opinion. The vote wasn't even close in this case. Usually these are like 5-4 cases, but not so here. Well, first off, it would have been 7-2, but Justice Thomas was recused. His son attended VMI, which I guess is a good reason to recuse. But this was a majority opinion. There was no question that Ginsburg was going to have this majority. There was absolutely no question at all. Let's walk through the Ginsburg majority. Okay, who's up next? I can't recall. Yeah, Lindsay? No, Audrey? Audrey, okay. You want to? Audrey, you want to walk me through the Ginsburg majority opinion, please?
Yeah, so she first starts off and says that even though she notices that there are differences between men and women, but you can't use these differences only for the purposes of basically giving someone a separate opportunity.
Very good, very good. All right, so Ginsburg concedes that there are some inherent differences between men and women. But so what? You can't make government policy based on these classifications that are premised on inferiority of women, right? You can't make governmental decisions based on fixed notions about the roles of men and women. That this is not a legitimate basis on which to achieve. Does the state have an important interest to have citizen soldiers? Yes. But the use of gender to get there lacks a sufficient fit, right? That gender is being used in too much of a fashion in this approach. Justice Ginsburg writes that when the government gives a justification, it has to be genuine. It can't be invented as part of the litigation, right? The government must give the real reason why they're acting the way they're acting. It can't rely on generalizations about men and women and their talents. And then she gives this test that the government must give an exceedingly persuasive justification to exclude women. An exceedingly persuasive justification. This is language that had floated around before, but she puts it in very clearly. So it's not enough that the policy must be rational or even substantially related, but you have to have a really good reason. You have to have an exceedingly persuasive justification. What does that mean? You have to persuade the justices that this sex classification is necessary, right? It's demanding that the courts second guess whether or not this is a necessary classification. And she says women cannot be afforded anything less, right? You can't get away with a sex-based classification unless you have a really good reason. And as I read VMI, I think Ginsburg would eliminate almost all sex classifications in America, perhaps with the exception of bathrooms and dormitories, and maybe not even there anymore. When Ginsburg was a private lawyer, one of her more famous, well not famous, but infamous reports was she said we should get rid of Mother's Day as a holiday because it perpetuates gender stereotypes. So she was very candid about this. Ladies' nights at bar should also be eliminated.
A local bar where I live actually just started men's night because so many of the men in town were complaining that there was a ladies' night and that women got discounted beer on that night, that they actually gave in to them.
Well, that was a voluntary choice, which I suppose is laudatory. But whether the state could actually bring a prosecution against a business for charging men lower rates for beer than for women, or charging men more for beer than for women. Think of like Craig v. Boren, right? Instead of a different age differential, you walk into a bar, if you're female, it's $1, if you're a guy, it's $2 for a beer. Or no cover, right? Audrey, you seem upset by that.
This is all coming to me now. All of the there's so many things that are like gendered.
Good. We've come a long way from the council schools.
Oh my goodness. I didn't go to those.
I know. But under the standard, it's very hard to see daylight between intermediate scrutiny and strict scrutiny. I think if a policy fails, if a policy can survive one, it's going to survive the other. But it's really hard to think of a policy that would pass intermediate scrutiny but then fail strict scrutiny. I think they're pretty darn similar. If you need to have an exceedingly persuasive justification, then just about all sex-based classifications go out the window. And I'll use the draft as an example. There was a case reference called Roscoe versus Goldberg. I always spell it wrong. Let me give you the right spelling. Is it Rockster? R-O-S-T-K-E-R. Rostker. I spell that wrong. There's another case called Rocksker. No, R-O-S-T-K-E-R v. Goldberg. And this case upheld the exclusion of women from the military draft. Right? It was actually brought by a woman who thought it was unfair that she can't be enrolled in the draft. The court upheld the classification because at the time women were not allowed to engage in combat. So as a result, they found there was a rational relationship, right? That if women can't go into combat, why are you drafting them? It wouldn't make sense. That's no longer the case. Women now are eligible for combat. And at the 2016, or I guess it was 2015, but during one of the Republican debates, they actually debated whether women should be eligible for the draft. I was thinking about this case, because if women can go into combat now, should they be eligible for the draft? You're shaking your head no.
I don't think so, only because it was the same argument I made a couple classes ago, that you could argue that not only does the government have an interest in an active standing army, but you also have to have an interest in making sure that your population is insured.
It's a Mull v. Oregon argument. You need to have women to reproduce back home.
So I'm just saying, and if I'm right, the draft is the ages from 18 to 26. So women only
is a selective
have,
service 18 to 40?
Top fertile age.
And so that's what I'm saying, is if you send all your young men and your young women off, the U.S. is already not repopulating at our replacement rate right now. We're already dropping below that. So I say that would be the argument you make. And I'm not saying that we shouldn't have to go to the draft because, you know, for whatever reason. I'm just saying that if you look at it from that perspective, if you send off childbearing age women to war and they're allowed to be in combat, then you're risking your population.
I would love to see someone make that argument when this case comes to the Supreme Court. I think people will. I mean, you have plenty of cases to cite. You can cite Bradwell about the women's place for reproduction. You can cite.
See, I don't like that.
You can cite Mull v. Oregon about the women you need to reproduce. You can't work too many hours.
No. See, I don't like that. But I do say, from a pragmatic standpoint, men cannot have babies.
Yeah.
I mean, there are countries where you had men go off to war, and you basically had these massive shortages of reproducing age people. You've had these situations.
And the baby boom after World War II, and then also during World War II, women went and did a lot of work that men had been doing because they got drafted and sent off. Like my grandmother did riveting on the wings of planes and stuff like that during the war. So, I mean.
I would love to.
Feminists saying like, let's cite Bradwell, let's cite this, because I don't like those cases, but I do have a problem with drafting women at 18 to 26, and if it is 18 to 40, even then that's a bigger problem.
So you would draft women who are not of child-rearing age.
I know at 25 is whenever it goes down.
I mean, if you're drafting men from 18.
Oh boy, you don't have any friends over 25, do you?
I know, like, statistically, I looked it up at 25 is your peak, and then it goes down. So, like, my fertile rate's going down. Like,
oh God, where are we now?
Audrey's citing Cosmopolitan.
I am. Oh my goodness, rescue us! Yeah.
So, even thinking about this was 16 years ago, etc., and the amount of personnel that we had versus that we actually used.
Yeah.
I don't anticipate there will. I mean,
we won't need a draft
ever. Right. The next
we can drone them to death.
Is going to be fought in a room like this with about 40 people from Las Vegas.
You can move a joystick. Yeah.
Absolutely. I mean, I don't think that Selective Service Act will even be a thing. I think we're still doing it because it's the law. But if we ever have to draft people, something's gone terribly, terribly, terribly wrong.
Maybe some sort of invasion of the home front.
I mean,
Red Dawn, right?
Yeah. Yeah.
Oh, if we have a civil war, we might need it. The Texas militia. No?
Lincoln said it first about what would happen if
Will the Republic be here in 50 years? We'll see. Okay, so I think we've beaten the Ginsburg opinion enough. Audrey, you can do the Scalia. You said you like the Scalia one. Well, I may like, but okay. You can say whatever you want. I don't care. So what'd Scalia say?
He basically, I liked in the video, I liked what he said whenever he said if women can't take the heat, then they wouldn't. But he basically said that Ginsburg is actually using strict scrutiny.
Yes.
In that the law would survive if she actually properly used intermediate scrutiny.
Very good. Right. I mean, Scalia, I wrote an essay about him after he died. There's an old, William F. Buckley was the editor of the National Review, a conservative magazine. And Buckley said the role of a conservative is to yell and to stand and say, stop, stop what you're doing, right? It's not necessarily that he wins, but he's the guy yelling stop all the time. I think Scalia knew he was going to be excoriated for this sort of dissent, but he was willing to say, stop what you're doing. You are now changing the doctrine. You are now watering down strict scrutiny. I'm sorry, you are now, not watering down, you're now beefing up intermediate scrutiny to the point where it's indistinguishable from strict. And he says, without a question, there's a substantial relationship here. The school's operated for over 150 years, or how many years it's been, right? You can't tell me that they don't know what they're doing, right? If we're going to second guess them and say, no, you have to do it like these other colleges, that is something like strict scrutiny. We need narrow tailoring. But intermediate scrutiny never required narrow tailoring. It only requires a substantial relationship. And can you argue that it's very important for this adversative method to have segregated dorms, segregated admissions? Yes, it is. Right? Is it narrowly tailored? No, it's not, because other colleges have done it differently. So the question is there a one-size-fit-all, or is there some discretion for the state? And Scalia would give discretion. Audrey?
Would you consider, sorry, my brain's like, but would you consider the court second-guessing a lawmakers, kind of like just justification, the justification measure?
Mm-hmm.
Kind of like second-guessing them?
It's exactly what it is, right? To demand an exceedingly persuasive justification is to say that the reason you've given is not enough.
Okay.
Right? That the reason the legislature gave is not enough to persuade us. We want more.
Okay.
Right? And no matter how persuasive the government is, it will not be exceedingly persuasive. Right? Again, I have difficulty thinking of what sort of gender-based classification survives post-Virginia. The only one I can think of is basically bathrooms and locker rooms and the like. And that's an issue that's litigated now quite a bit.
So from before Virginia, we didn't have the extra.
Not the exceedingly persuasive standard. To be fair, it was kind of floating around, but the way Ginsburg framed it expanded the doctrine.
Okay.
Okay. Questions on Virginia? It's also called the VMI case, but I'll sometimes say VMI inadvertently. Okay, let's go into the last case. The last case doesn't really fit anywhere. It's kind of weird, right? We have this entire neat framework of non-suspect classifications and quasi-suspect classifications and suspect classifications. And then we get to Cleburne, right? Cleburne, Texas, not too far from here. I don't know who's next, Chelsea or Tyler? Okay, Chelsea. You want to run me through the facts, please, in Cleburne versus Cleburne Living Center?
Yeah. So the Cleveland Living Center wanted to operate a group home for 13 mentally ill people.
Yeah, and Randy and I struggled with this because we didn't like the R word, but the R word was actually used in the written opinions. We actually labored over this, and so we came up with the compromise of just putting scare quotes around it, so to speak. But that was the word they used, and in fact, in death penalty cases to this day, if a prisoner is mentally handicapped, they say mental retardation. To this day, they use that word. That's still the word used. So anyway, well, it's in there, but you can use whatever euphemism you like.
I used to work with them, and we called them IDD for intellectual and developmental disabilities.
Intellectual, and what was the other one?
Developmental disabilities. So,
yeah, I mean it's. Oh, you worked on this sort of case, so you're a perfect person to talk. Okay, so run me through the facts, please, Chelsea.
So the city of Cleburne told the center that it needed a special permit to operate a facility. They actually classified it as a hospital for the feeble-minded.
That word has some salience now, doesn't it?
Yeah. The city council denied the permit.
Good.
And the center contended that if the residents were not mentally ill, the permit would have been granted.
Okay, very good. Now, no one has taken property two, is that right? Usually when people have ConLaw, they've already taken property two, or they'll take it soon. So I'll give you a preview. Zoning law. Lindsay, you know about zoning law?
I love that Houston really doesn't have.
We do not have a zoning law.
I had Professor Festa.
You took property two already?
Well, no, I had Professor Festa for Property 1, and he works on, or he litigates for zoning laws.
He does.
He's
Well, let me give you a general background. We've already done a zoning case. Ooh, pop quiz. What zoning case did we do? Not really slaughterhouse.
Louisiana.
Not slaughterhouse.
No, the one where they had the segregated neighborhoods.
That's good. That's Buchanan v. Worley. Good. But think of another one that's even more relevant to here, where a group applied for a building permit.
Oh, it was.
See if you guys remember.
Yes.
A building permit to construct something.
Oh, the
Oh,
church.
the buildings
church,
with
yeah.
What was the name of that case?
Bernie.
V. Flores. Yeah, you have to start connecting things. Because if I give you a fact pattern with a building permit, you think, oh, Cleburne and Bernie v. Flores. The ICWA was a license to run a business, so it wasn't a construction permit. Right. So what was the issue in Bernie v. Flores? Right. The issue in Bernie. Oh, good. I got these things. The issue in Bernie v. Flores was the church wanted to expand, right? They didn't have space. They lacked enough space for their parishioners. And they applied for a special use permit. They said, we need more room to expand to fit all of our members. And the city said, no, this is a historical zone. You can't destroy this thing. It's a historical site. At that point, what happened? They sued for violation of the free exercise, the RFRA. Right. The fact that the church had a free exercise claim put it in a unique place. Generally, when the government denies your zoning permit, you're screwed. Right? The zoning boards have almost unfettered discretion to grant these sorts of permits. They usually don't need any reason at all. And almost every case, the federal courts are hesitant to intervene to challenge these ideas. Cleburne is very much the outlier. Here, they were denied the special use permit to construct their home, and they went to federal court to sue about it. This is very rare. I can't stress this enough. Generally, when a zoning permit's denied, you are in trouble. It doesn't matter why. But here, right? Here, the government was put to a very high burden. Now, Chelsea mentioned a minute ago that the reason why they were required to have this permit, what am I saying? Audrey, why did the government say they were required to have this permit? Let's just try it like that.
Wasn't it because they just had to be supervised the whole time, I guess, and it was only like a small amount of people?
What were they afraid of? What was the government worried about here? Chelsea, you wanna?
So I believe they had a couple of reasons. It was across the street from a junior high, and so they were afraid. They said they were afraid that the kids would terrorize or pick on them.
Right, so it's not that the people living in the home would harm the children.
Yeah.
It's the other way around, that the kids would taunt and torment the patients. What else?
There was a nursing home or another facility. They feared how the elderly residents would feel in the neighborhood. And then they also said it was on the floodplain.
Yeah.
But that didn't work because there was already other creeks on similar locations.
Yeah, so I mean, the government puts forward a couple different justifications, right? And the court does something very strange. The majority was by Justice White, who was a Kennedy appointee. He was the football player guy, Justice Whizzer White. Justice White said there were a couple reasons given. One is that property owners in the area were afraid of these residents, right? They just didn't like them. And let me tell you something. With zoning, that's generally a good enough reason, right? I gave an anecdote in class every year. I think Lindsay heard it on a tape from last year. But I was clerking in Western PA in a small town. And a group wanted to open up a methadone clinic. Now, what's methadone clinic? It's a treatment for people with various heroin and opiate addictions, right? It's supposed to help them wean themselves off the drug. Whether it's effective or not, it's not important right now. The group found a place to open the clinic, and they announced they applied for the permits. Almost as soon as they get the permits, the city council has an emergency meeting, and they freak out. And they pass a resolution saying that you cannot build a methadone clinic within 200 feet of a school, playground, church, nursing home, park, right? The fear is we don't want these drug addicts coming near where people are. Now, let me show you something. If you draw a map of any city and you draw a 200-foot radius around every single school, park, nursing home, etc., there's nowhere left, right? Basically, every single place in the city is off limits. Now, fortunately, this is Western PA. There's lots of industrial area. So they actually found a spot in the outskirts of town, far from anyone, where they were not within 200 feet of any sort of special place. What did the city do? There was a strip of grass in front of the site. They designated that a park. They designated the strip of grass in front of the facility as a park. This actually went to court, and the case went on for years. I was only there for, I think, part of it when I was clerking. But I think eventually the methadone clinic prevailed and got award of damages on equal protection grounds. But generally, you have to show some very egregious conduct to win in a zoning court. But here, the court says that negative attitudes are not a permissible basis to treat a home for the mentally handicapped differently than other homes, right? That merely having a fear of these people is not enough, right? What about the fear that the high school students will torment and taunt them? Again, the court says this is not a good enough justification, right? In other words, this is not a persuasive enough justification. Oh. What about the fact that it's in a floodplain? Well, you allow nursing homes and hospitals in the same floodplain. Right? What about you're concerned about too many people living there? Well, then how about you limit the number of people? Don't ban the construction at all. And effectively, the court goes point by point, one at a time, and says, no, not persuasive, not persuasive, not persuasive, not persuasive. What does this look like? This looks like the same sort of scrutiny that we just saw with Justice Ginsburg in the Virginia case, right? It looks a little bit like heightened scrutiny. But the court does not say that there's a suspect or quasi-suspect class. They do not say that we have here some sort of heightened intermediate level scrutiny. According to the majority, that this is a non-suspect class, mentally handicapped individuals. And because it's a non-suspect class, we use rational basis review. But the essence of rational basis review is deference. The court doesn't second guess the wisdom of the legislature. The court does not challenge the persuasiveness of a government policy. Under rational basis, so long as there might be some good reason why you treat ophthalmologists different than opticians, you're fine. So long as there might be some reason why mentally handicapped people shouldn't live there, that's enough. But here the court did something different. They suspected that this law is motivated by what can be called an animus. A-N-I-M-U-S, animus, which generally means a hatred or dislike. That this law was motivated by a fear or a hatred or a dislike or an animus of mentally handicapped people. And that because this law is motivated by this improper justification, the court set it aside, right? This was a very strange case because it didn't fit into this neat three-layer cake. And Justice Thurgood Marshall, we've talked about before, said, whoa, 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 what's going on here, right? I thought we had rational basis like Lee Optical, where the court defers to any sort of rational statement of policy, whether there's a real reason or not. But here, the court says, we want the real reason why you're acting, and it better be persuasive. And if it's not persuasive enough, we're going to assume that you're a bunch of bigots and you don't like these people. Now that's done all the time in strict scrutiny, but it's not done on a rational basis. Justice Marshall sounded the alarm, so to speak, that something else was going on, that this was not the usual approach of the court to non-suspect classifications. Okay. Who's next? Audrey or Tyler? I'm not sure. Audrey, why didn't the majority go ahead and recognize that this was simply a suspect or quasi-suspect class that gets that laws burdening them are reviewed with heightened scrutiny? Why didn't they just say that?
I guess because they didn't. Wait.
Why didn't the court say that mental handicap is a quasi-suspect class like gender is?
Wasn't it because there was a difference in treatment in like mentally disabled people and other groups of people, just in general?
It's immutable, to use the phrase, right? You're born with I guess you can maybe acquire it later. Generally, you're born with these handicaps, same way you're born as a man or a woman. Why, Audrey, why didn't the court just say that mental handicap is a quasi-suspect class, that these people have these immutable characteristics and that the government can't treat them worse because of how they were born?
Now I'm like wanting to put them in that class and stuff like that, but I think because they wanted to say they were using, what I'm thinking is what they were trying to use the rational basis test, but give it more of like a...
Yeah, more of a bite.
Yeah.
It's often called rational basis with bite. But why, though? Why didn't they just straight up say what they were doing and say this is a quasi-suspect class? Marshall did, right? Marshall said this is a quasi-suspect class, right?
I'm trying to think of
What's the reason why? Tyler, what do you think? Why didn't they just go ahead and say it's a quasi-suspect class?
Justice, the majority opinion gave a few factors. One thing that stood out is he mentioned that they weren't politically powerless.
Yeah, did that make sense to you? Did that click with you? I mean, of all the people who lack political power, my goodness, these people who can't articulate for themselves by basing their very nature. But again, those are the court's factors, but why do you think the court really was hesitant to expand?
Yeah, I think what
That's my
said
question.
After that is okay, so we do it in this one case, and we then set parameters that we're going to have to consider if something's slightly different. Is this another class and another class?
Very good. The word about opening up floodgates. Okay.
I think they even mention alcoholic as the type of people that could have been residents of this particular hospital.
Very good. Right? They were about opening up the floodgates. If the mentally handicapped were now quasi-suspect, then lots of other categories, people with disabilities, right? Alcoholics, maybe drug addicts, right? Where do you draw the line? Methadone clinic people. It would empower the courts to closely scrutinize huge chunks of the society, right? Now all these zoning laws, which we usually just defer to, will now be carefully scrutinized. It would give the courts too much of a role. So in other words, this was a one-off, right? They said, this is really bad. Cleburne really screwed up here. Let's let the Cleburne people win, but not change the doctrine going forward. So this approach came to be known as heightened rational basis scrutiny, or rational basis scrutiny with BITE, B-I-T-E. The court was never particularly candid about what it was doing. They sort of just punted and said, well, we're doing rational basis scrutiny here. And Marshall's like, no, you're not. We'll come back to another case in about, I think next week, where the court also employs a sort of rational basis with BITE. This is a law from Colorado where the people amended their constitution to prevent giving gays and lesbians certain preferential treatments under law, certain anti-discrimination laws. There too, the court didn't recognize sexual orientation as a suspect class or a quasi-suspect class. They applied rational basis scrutiny, but they applied it with a very rigorous approach. So you're seeing, right, with the VMI case and with Cleburne, this neat 3-layer tier cake starts to crumble very quickly. And it doesn't help very much because the court doesn't consistently stick to these 3 tiers. And even when they stick to the 3 tiers, they apply them in a very fluid fashion. What's underlying all these decisions is a simple fact. The courts will sometimes find a law is motivated by an improper justification. Why is it improper? The court thinks so. There are 5 votes for that. And if the law is motivated by an improper justification, then it will not be upheld. Right? It's very rare for the court to say, we think this was motivated by a bad reason, but we'll let the government win anyway. So it's a very strange approach. Okay. Questions on Cleburne? Okay. We've done today the equal protection, the 3 tiers. In class tomorrow, we're going to shift. We're going to move on to the topic of substantive due process, the notion that the due process clause of the 14th Amendment, which protects liberty, that word liberty has a substantive component, that it refers to rights, that it's not just about process, but about what rights are protected. And we'll discuss how the modern court, following the New Deal, identifies what rights are protected. As always, with substantive due process, there's the question, how do you know? Right? Says who? Right? What is the right? Is it a right of privacy? Is it a right of abortion? Right? Where these rights come from? How do you know what they are? And this topic will begin the discussion by identifying what these rights are. Anything else? I will see you all tomorrow night, and that will be the end of the week. We are off on Thursday, and you're not here on Friday, so we have 1 more class this week. And then we are almost done. Oh my God. A reminder, no class on Tuesday the 9th. No class that night. I will be in New Orleans. It's on the syllabus. Tuesday the 9th. Okay. All right, I'll see you guys soon. Have a good week.